morning, everyone. Thank you so much for joining us today for this breakout session on navigating international compliance. Our panel today are Kevin Austin, David Ellis, and myself, Bernie Payne. David is the Director of Business Development for PGC Group, a first choice employer of record in the USA and Canada. And these are particularly lucrative but complex countries to place contractors or operate in. So it's really wonderful to have David's input here today. Kevin Austin is a director at Access Financial, which is the European leader in the international mobility industry. Trust me when I say Kevin knows his stuff. And finally, I'm an independent legal and compliance consultant who's worked in staffing for more than 20 years, both in the UK and abroad. And I've set up and managed international placement capabilities for multiple recruitment agencies. So whether you're looking to place contractors internationally or indeed expand your business to operate in other countries, this should be a really helpful session for you. So firstly, I think maybe we should just start with a bit of context. So what are the main considerations for placing contractors in other countries? And I think that the main issues are around right to work, payroll capabilities, possible routes to market, tax and social security, obviously, contracts and costs. So if we take them one at a time, right to work and visas. One of the main things that you've got to sort of work out right at the very beginning is, does the contractor need a visa to go and work in the country of that assignment that you're trying to fill? And if they do, what type of visas are available? Because obviously different countries have different visa rules and different visa types. How long the visa takes to process is also a really key consideration as well, and the costs to get that visa. And actually all of those things combined, I think, they have a significant effect on actually whether an international assignment is even a viable one or not. The next thing I think is that ability to payroll. So some agencies may well have internal capabilities, so an existing office or some other payroll capacity in the country of assignment, but the vast majority won't, which means they need to look externally. And often the way to do that is for the agency to contract with a third-party management company. And then the management company contracts with and payrolls the contractor. And these management companies fulfill such a vastly important role, but you do need to do your due diligence on any management companies you might choose to use. And I know we're going to be covering that today as well. Then I think you need to think about what are the routes to market in the country of assignment. Generally two main types, either employed or self-employed, but within those types, there may be multiple options depending on the country that you're looking at. So it's really important that you understand and you know what the options are and whether they're possible for the type of assignment you're looking to fill. The type of engagement also determines what employment rights, if any, the contractor might be entitled to while they're engaged in country. And that can be important for a whole host of reasons, but particularly for agencies in relation to any termination obligations relating to the assignment, particularly minimum notice periods and whether notice periods are paid. A lot of contractors, as we know, do ask to use an existing payroll model that they already have set up in their home country. A perfect example would be a UK limited company that a contractor wants to use for an assignment elsewhere. Now, what I would say is there may be some circumstances where that is possible and appropriate, but it is generally not recommended, mainly because of the next point, which is all about tax and social security, which of course is the equivalent of national insurance in other countries. And you need to consider the tax and social security laws and obligations, both in the country of assignment and of course in the contractor's home country as well. and the availability of any double taxation treaties or similar. So, there's a lot of information that you need to be able to understand and absorb and be able to communicate effectively to your clients and your contractors. But it's not just about communication. You do also need to think about contractual arrangements as well. So the normal process is that if you're using a management company, the agency will normally contract with a management company, and then the management company contracts with the contractor in country. But there are some countries which actually require the contractor's employer to also contract with the end client. So actually the agency sits outside of the payment chain and actually is only paid on what we call a margin only basis. So having clear, robust contracts in place to manage international assignments between all the parties is really key. And then finally, obviously, there's the issue of costs. And there's the obvious ones, visas, travel, accommodation, but also how to set up the relevant route to market or assignment. So, for example, if a contractor is looking to set up their own limited company in the country of assignment, well, there are lots of countries that have quite high capitalization requirements to set a company up. So that's a cost that needs to be considered. If you are using a management company, you need to consider their costs as well, of course. And that can be anywhere between 3 to 8% of the contractor's pay rate, depending on the country and the management company you're using. And most of those costs are generally paid for by the contractor. And that has a potentially significant impact and effect in terms of the contractor's take-home pay rate. So it is important to have a good awareness of what all those costs are so that you and your contractor know what you're getting into and what the contractor is actually going to get out of the assignment. Kevin, what are your thoughts on the main considerations for international placements?
Well, I was going to talk specifically about the effects of Brexit on placing contractors from the EU into the UK and from the UK into the EU. And of course, the major change has been on the 31st December 2020, that their freedom of movement just came to a sudden end. And now, post-Brexit, you can visit the EU if you're a UK national, but you can only visit in order to, for tourism. You could attend conferences, but you have no right to live there, to work there, or even to study there anymore, nor to play musical instruments if you happen to be a musician. So this is the major change that's occurred. Now, if you were living in the UK as an EU national before Brexit date, and you've applied for status in the UK before the 30th of June, which is only tomorrow, then you can continue enjoying the same rights that you had prior to Brexit. The same is true in the EU. If you're a British person and you were living in a European country prior to Brexit, and you have registered, then you would again can live, study, work there as you could before. Your rights are preserved. The date, of course, is looming to say the least, and you now will have to have good reason to make application after the 30th of June. If you don't have justifiable excuse, then you may not get a settled or pre-settled status. Now, if you are now if you're traveling, if you're a UK national, you're traveling to the EU, you can be in the EU only for 90 days in any 180-day period. Now, if you look at the Schengen bloc, which is 27 countries minus 3 or 4 that are non-Schengen, so most of the EU is Schengen, those days are taken in aggregate. So the 90 days would include any days spent in France, say, and in Italy. But there are countries that are not in Schengen, so places like Bulgaria and Romania and Cyprus, where you can spend 90 days in any 180-day period. It doesn't count towards the aggregate within the Schengen area. So this is something you need to bear in mind. Now, post-Brexit, if you don't have settled status, then you're going to need a work visa in order to work abroad. And this is the main constraint on placing UK people into Europe and European people into the UK. Now, as you've already mentioned, to obtain the legal right of work, essentially there are two ways of doing it. It's either on a self-employed basis or an employed basis. When it comes to how long it takes to get a work permit, typically it is easier, quicker, if you're going to apply on an employed basis, and self-employed is more difficult. The tests are more difficult. You have to demonstrate that you're going to run a viable business. And of course, this is all very subjective, whether you are or you're not. And so it can be not only a long time to process, but problematic. You may well not get the visa that you're looking for. So this is not straightforward. The only country where there really is an effective fast-track method to getting an employed work permit at the moment is actually the Netherlands. Now, if you've got an EU candidate who wants to come to work in the UK, then the obvious route is what is called the skilled worker visa. Now, the skilled worker visa replaces the old Tier 2, and anyone who was a sponsor of the old Tier 2 become a sponsor of the new visa. Otherwise, you need to apply to become a sponsor of the skilled worker visa. There are fees attached, and there are processing fees attached. Now, can a recruitment company actually act as a sponsor for skilled worker visa? And the answer is yes, provided they're looking for staff to work in their own organization. And the answer is no, if they're thinking of getting a work visa for somebody and then lending them on to the client. That is not permitted. And the guidance notes from the Home Office has been that if this turns out to be the case, you will have your license revoked. So in order to get a skilled visa in the UK, there are a number of conditions. You've got to work for a UK employer, and that employer has to be approved by the Home Office. You have to have a certificate of sponsorship from your employer with information about the role that you've been offered in the UK. You've got to do a job that's on the list of eligible occupations. There has to be a minimum salary. Now, this depends upon the occupation that you're in. And the eligibility also depends to some degree on the job that you're in. You've got to have a confirmed job offer before you apply for the visa. You've got to have a knowledge of English. You've got to be able to read and write, and this will be tested at the time of the application. So it is not like it was formerly. If someone was able to do the job, now they've got to score 70 points, meet all these criteria, and then you can make an application. Now, typically it takes about 3 weeks to process a skilled visa, and you can apply up to 3 months before the job is to start. So this is another layer of red tape which we didn't have prior to Brexit, and it is the biggest constraint on placing contractors from the EU into the UK and from the UK into the EU.
Yeah, I think that it's also quite expensive, Kevin, isn't it? I mean, you know, for a UK company looking to bring an EU national, or in fact, actually any national now into the UK. You know, there is quite a lot of cost because... Well,
there is a cost. There's certainly a cost. Now, the license fees, they range from between £538 to £1,476, depending upon the size of your business. And if you want to be fast-tracked to get the approval quickly, there's another £500 on top that you need to pay. And then with every application, that cost is between £610 and £1,408 per application. In addition to that, there's a healthcare surcharge, which runs at about £624 a year, which any immigrant needs to take in order to contribute towards the National Health Service. So yes, it is expensive, it is bureaucratic, it is a pain, no question about it.
Thanks, Kevin. So let's sort of move away, I guess, from Europe for a little bit, and focus now on the US market. So, David, why is the US staffing market just so attractive to UK firms? What is it about that market that that offers people something that they perhaps don't get in the UK or Europe? And what are the key differences then between the UK markets and the US?
Yeah, thanks, Bernie, and thanks for having me. It's a really good question. Obviously, this is an international panel, but I'm very, very biased and I'm very, very focused on the US market. So you're going to have to excuse me for that. I mean, we've worked with firms over a number of years, helping them launch and set up in the US. Really, the reasons why it's an attractive market. Number one, it's an enormous market. So it's in and around at this point about $150 billion worth of staffing revenue in the US market. Obviously, it's one of the leading economies globally. In 2020, it was a third of global staffing revenue was in the US. So it's just this enormous market, and I think sometimes people forget that. So that's a good starting point. Huge market, a lot to aim at. Number two, the fees are higher than most other parts of the world, which is great, particularly when compared with the UK market. My background is that I was a recruiter in the UK market, so I'm familiar with margins of anywhere from sort of 15 to 20, maybe 22 to 25 if you're lucky. Whereas hygiene standard in the US is 20 plus. We have a lot of clients who are charging 30% or even more on the contract deals that they're running through us. So much higher fees, and there's a few reasons for that. It's a less saturated market for one, so it sort of depends where you get your data from and who you're asking, but there's roughly an equivalent number of agencies operating in the UK market when compared to the US market. So we've got the market is 4 or 5 times the size, but you've got roughly the same number of agencies operating in that market. Now, obviously, the makeup of those companies is quite different to the UK. There's some really big players in the US market who will only count as one staffing company, but they have a big reach. So it's not an easy comparison to make. But point being, on average, much less saturated in the US market. Margins are higher, as I said, and typically rates are also higher. So, again, I always compare things to the UK. I know we're talking internationally, but the average deal value is going to be anything from sort of 2 to 4 times what you can expect in the UK. So those are some really good reasons why it's attractive about it now today, is that the barriers to entry are much lower than they ever have been. So, whereas when we were working with firms 10 years ago, it was quite a significant investment of time, energy, resource, and building out a proper strategy to launch in the US market. Nowadays, with the sort of remote way that the world is going, and we were talking about this a little bit before the session, but the access to the market is more straightforward than it has been previously. So you can be a firm even in the UK, accessing a talent pool in the US and accessing a client base in the US. So I guess that's what's attractive about it. And then, if we're talking about the differences, there are a lot of differences. So that's probably the one biggest mistake that I see people make, is that they just expect, hey, this is just going to be like the UK. Obviously, they speak the same language. I'm sure all of the laws and compliance are the same. And you couldn't really be further away from the truth. Often people describe the US as, what's the phrase? It's the US and the UK is 2 cultures separated by a common language, meaning we have the same language, but that's pretty much where the similarities end. So a big factor in that is just the legal and the compliance and the cultural landscape of America. So this is really, really basic stuff. But obviously the way that America works is on a federal, state, and then municipal level. So you've got federal legislation, federal taxes that are set by the federal government. And then each individual state actually has quite a bit of power individually to then exceed that federal legislation. And then you get, obviously, local areas, local jurisdictions like cities, which also have the option to exceed the state level of legislation. So you'll take a city like San Francisco, for example. You've got federal taxes, federal legislation to contend with. You've also got California state and California taxes, which is notoriously quite complicated. And then San Francisco has decided to add a whole bunch of complexity on top of that. So if you're placing workers within the San Francisco city limits, there's a whole bunch of other things to contend with. And so that's a really big difference, is that you should view it as 50 countries rather than one country. That's a really good starting point. And that goes from a compliance perspective, but it also goes, it really rings true when it comes to just cultural differences as well. It's an enormous place, and all of the states have very, very different cultures. This was really, really illustrated, obviously, in the election we had last year. Really, the way people see the world, very different. So if you're recruiting in New York, you're going to have to take a very different approach to if you're recruiting in North Carolina or Texas, where they might be a little bit more relaxed and a bit more open to having a conversation. Whereas New York, it's very fast paced. You need to move quickly. You need to show value very, very early on in the relationship. So that's a huge difference, and a huge difference from a starting point. And just a couple of other things I'll touch on as well. Attitude to employment is very different in America, and all of the compliance and legislation around employing workers is very different. The default notice period is at will, meaning you do not have a notice period. You can be fired on the spot. You can also leave your role on the spot. And a lot of workers who have even been working full-time as a employed worker for a company for 10, 15, 20 years, they'll still have at-will notices. And so that's where the kind of, you get that stereotype from movies of people walking out with a cardboard box, getting fired and leaving with all their stuff. That's what it comes from, and that genuinely does happen in the market. And obviously that means that the market moves very, very quickly, even the perm market. Also attitudes to things like paid leave and paid sick leave. So paid sick leave is not a federal requirement. It's only a requirement across, I think more and more states are picking it up, but it's only on a state level. So most of the well-known states have paid sick leave laws, but it's not required across every state of the US. There's no requirement for paid leave, as in annual leave. And then I guess the third thing I would say is the third key difference I would pull out is the contract market itself. So we're very focused on the contract market. That's where we help our clients. But we talked today about the self-employed versus the employed model. The US, 9 times out of 10, it's going to be the employed model. It's called W-2 versus 1099, which is self-employed. And what that means is there's a whole bunch of responsibility that comes with engaging that worker. So you're employing them, which means you're going to have to manage all the local, jurisdiction law. You're going to have to give them access to things like healthcare benefits, which is a federal requirement in the US, paid sick leave on a state-by-state basis, and a whole load. So those are probably the three core differences I would take away: is the federal, state, and local landscape, attitude to employment, and then finally just the contract market and the differences there.
Thank you so much, David. That was awesome. And I think, the way I think about the US market is, as you said, the W-2 option is the most commonly used. It is by far the most expensive, but it is the most compliant. And it's actually the way that most contractors want to work. And that in itself is quite a cultural shift, right, compared to the UK, whereby self-employment is, if you like, the default in the UK. You have to fight quite hard to get your rights as a worker or an employee. And that's not the same, in the US. It's people expect to be employed as the default, and they need really good reasons to go another route. Even though the benefits may be slightly different compared to the benefits of being employed in the UK, there is still that cultural thing around, employment being the best way to go. But it does add cost, doesn't it? For an agency.
Yeah, that's a really good point, Bernie. That's really spot on. It's like people just expect to be W-2 employees. They don't, they can be engaged as independent contractors, but they don't really expect that. And one of the big reasons, and this is also something that brings in the additional cost, is the benefits. There's no national health service. So, people need to get their own medical coverage. If you're not getting it through your employer, it's incredibly expensive. And so, in 2010, when Obama was in office, he brought in Obamacare, which is also referred to as the Affordable Care Act. And that requires employers to offer medical, supplementary medical to employees. And so that's always a big reason, alongside 401k, which is like a retirement plan, dental and vision and all the other benefits. But that's a big reason why people like to be employed. When it comes to the cost, it's probably quite a different model to what people are familiar with elsewhere, in that because the contractor or the worker or whatever you want to call them, because they're employed, you're not going to be charging them for the service and for the cost of the employment. So it goes on top of their pay rate. But typically what happens is that gets passed through to the end client. So it shouldn't add additional cost to the agency. It should really be passed through to the end client. So just to give you a typical example, let's say for the sake of argument, someone's on $100 per hour. The employment cost on that is going to be in and around 20%. So it's going to be 100 plus the 20%. And then you'll put your profit margin on top of that. So you might charge your client $145 or $150 an hour. And that's a pretty typical kind of ratio.
Yeah, and I think, as you said, you're right. It isn't the agency that usually takes on that cost. And of course, clients, if they are also based in the US, they are used to those rates and they are used to those costs. So this isn't new for them. So a lot of agencies kind of feel like those employer burden costs, if you like, plus their own markup, means that US clients or any client is just, it isn't going to want to touch a US contractor, but they are used to it because rates are higher, margins are higher, and they are used to cost because the vast majority, of contractors or temporary workers are W-2s. So they know what that is. I think the thing is that the risk, I think, really for agencies is unless you work with a really good partner like PGC to really help you understand what all those costs are, you can run the risk of engaging with your client maybe too early in the process and agreeing an amount with them, a charge rate, and then think that you can work down to a pay rate. And often, of course, that's just not the case, is it? And you can end up then having a mismatch of expectations.
Yeah, absolutely. That's a really unfortunate error that we sometimes see people making, where you're sacrificing your whole margin or potentially you're going in the negative because it's not been priced up properly. Yeah, it's exactly right. You need to, I would always say, get some advice before you engage with your client so that you can make sure you're negotiating the right margins, which will encompass the cost as well as your profit margin. And typically that profit margin is at least 25%, if not 25 to 35%. So you can still expect to get a healthy profit even after all the costs are taken into account.
Can I just ask something, David?
Please.
Bearing in mind that the employment law is radically different from what we're accustomed to in Europe, what is the driver for contracting itself? Because if you can release people very easily and you're accustomed to the on costs in any case, whereas I think in the UK, the expectation is that the all-inclusive rate magically covers every conceivable cost, which it doesn't. But if people are ready to pay that in America, and they can also release people easily, why is contracting so popular?
You mean from the contractor's perspective or from the client's?
No. I'm talking about from the end client's point of view. Why do they not just engage people permanently or as permanently as they want, rather than contract?
Well, there's a whole bunch of reasons why. It's a really good question. There's a whole bunch of reasons why companies would want to take on, outside employed workers. Really, and it comes back to what Bernie said, just the attitude is so different. Even like we said, even a permanent employee can be let go on very short notice. But, often it will be on a project basis. So, we actually don't want a permanent employee and we want to outsource all of the headache and painful stuff around employing workers. We want to outsource that to a staffing agency. Maybe the staffing agency are doing it in-house. Maybe they're using an employer of record like us. Often it's just to get people in the office on Monday to start a project and get working on it straight away. knowing that it's not going to be a permanent need within the team. There's also quite a few reasons why people don't want full-time payroll workers on their books, from budgetary all the way through to compliance. For example, if you're in a new state, you may not want to have workers in California on your books because then you're going to be paying taxes in California. So that's where you would outsource the people, the workers there.
Okay.
Does that answer the question?
Yes, it's very clear.
It was a good question, because it's just the
even better answer.
People often ask that from the contractor's perspective, and the reason for that is the reason that contractors look at short-term engagements is typically that they're getting a higher rate than they would if they were, employed.
Cool. So, if an agency does choose to use a management company or employer of record to payroll contractors internationally, wherever that international location may be, we have already touched on the need, if you like, for due diligence on those companies, those management companies. So I do think it's worth just taking just a little bit of time and going into that in a bit more detail. So personally, I conduct very similar checks on management companies as I would for a UK umbrella. So I will put together a due diligence questionnaire that covers both the company and then each country I'm considering using the management company for. Because you can have a really good management company, but that doesn't mean they can compliantly supply into every single country you're interested in. They will have countries that they're better at and countries that perhaps they're not so strong in. So the types of checks that I would always do, if we're talking sort of higher, company level, would be things like trading history, financial security. I always ask to see their customer service statistics and evidence of feedback and the number of complaints that they get, both from their agency customers and, of course, the individual contractors that they engage. Because yes, of course, compliance is, really important. We all believe that very strongly, but you still need to make sure they're going to give you a really good service and your contractors a really good service, particularly as those contractors will be in countries that they are unfamiliar with, and therefore they're going to need to want that support. And they, I think it's right that they feel they are entitled to be able to utilize that management company for those needs. Obviously, I would ask them about any investigations that they may have had in the past or that are ongoing at the moment from any type of regulator or statutory body. I also ask whether their accountants and compliance advisors are in-house employees or if they buy in that from an external source. And I always prefer in-house accountants and compliance people. I think it just shows that the company is prepared to invest in needed expertise. I also ask whether they have a wholly owned entity in the particular country that I'm looking to supply contractors to, or if they subcontract the payroll service to someone else. And if they do subcontract to someone else, then I'll do exactly the same checks on their subcontractor. The number of contractors that the management company is currently supporting or has supported in the past in that particular country. So moving from sort of high level now down into the specifics of that, that particular jurisdiction. I asked to see their insurance cover in that particular country, and I'll check the types and levels, and of course ensure that the insurances cover the workers' acts and omissions and any employer's liability or workman's compensation or equivalent requirements, because obviously that's clearly key as well. I always ask what the available routes to market are in the country that they offer, because not every management company can offer an employed or self-employed or any variant thereof. Some will only be able to offer one. And what employment benefits they offer under each model, again, in that particular country. Clearly, you want to confirm, or you want them to confirm, that all the income that they pay to the contractor is made in that country and declared for tax purposes in that country. And I would want to know what their management fees are and how they compare with other companies as well. And then I think, just as a sort of general overview, I always ask about the approximate retention percentage for each route to market. Obviously, it's never exact. It's always based on personal circumstances. But I'd like to get a sense before I start negotiating rates with clients like we talked about, David. I want to get a sense of how much of the rate that me as the agency, how much that I'm paying to the management company is actually going to the contractor as take-home pay. Not because there's any sense of money going missing, but it means that if there are employer burden costs that I have not yet understood, it's at that point that I can take stock and make sure that I do understand them, and manage them appropriately. And then I think just the final thing that I would look at and ask any management company to confirm is that, if we have a temporary worker that is going in for a 18-month assignment, once they leave that country, I want them to be able to confirm to me and provide evidence that all the in-country setup is properly closed down once the assignment ends. Because there have been some horror stories around contractors remaining liable for ongoing tax and social security in a country that he or she no longer resided in. So, I think that's really important. But Kevin, I'm sure you've got lots of other ideas about due diligence as well. So,
well, you covered everything very comprehensively. But let's just go examine the topic again. The question is whether you should use a management company or not, because the recruitment agency's got to decide whether it's going to use a management company or it's going to do it itself. And increasingly, we're finding people who are setting up their agencies abroad, they say, well, we don't need you now because we've now set up in wherever it may be. And the questions that I would put to these people is really, are you geared up to do this competently? How certain are you of all the rules that affect contractors in a specific country? Are you expert in them? And have you taken all steps possible to avoid any breach of immigration, employment, tax, social security, and labour leasing law? You've got to have a complete understanding of all these matters. You really do need to know how double tax treaties work if you're handling people from another country to work in a given market. You need to know how the social security treaties work if you're going to maximise the use of those. So to be expert in this is quite an undertaking. And of course, if you get it wrong, you've got no one else to blame. I mean, no one ever, in the old days, they used to say, no one else got sacked for buying IBM. But handling your own international contractors and getting it wrong can be a major headache. And who is going to sort out, what is the ensuing mess? So these are the first things that I think before people are really confident about doing themselves, they've got to ask, what are the inherent risks? And is it actually worthwhile taking it? Bearing in mind that the costs are not directly borne by the recruitment company in the first place, although it may, of course, affect their margins. But now, if I was going to decide which management company to use, of course, I accept everything that you said previously. But I would ask some questions, and I'm sure you do anyway. Does the management company, do they understand all the relevant laws? How do you know that they understand all the relevant laws? And what tells you this? What do they know about taxation? What do they know about social security? What do they know about immigration? What do they know about labour leasing? I mean, do they have any labour leasing licenses? So, yes, of course, everyone's going to purport to know everything, but what's the basis for your confidence in the answer? That's the first thing. So, secondly, are they able to give you the assurance that you're looking for? I mean, is there a track record, which is what you've already alluded to? Because this business is not difficult. There's no real barrier to entry. But so you have to be particularly careful that you're not getting into bed with someone who really doesn't know what they're doing. It is very easy. And now, things will go wrong. There's no question that they will go wrong. And it doesn't matter how good your quality control is. You will miss something. Perhaps the contractor hasn't told you the whole truth. Perhaps they've got a very large income in that country that they've not disclosed to you at the time. All of these things happen. Now, who is going to be around to deal with this problem? Is the one-man band really going to be able to support you when things go wrong? Or will you find they're simply not available? Do they have the capacity to deal with this? I mean, not only are they going to be there, but could they deal with it if the problem arose? And do they have the money to devote to dealing with your problems while they are running what is probably not a very large business? So these are very, very important concerns. Now, what supporting evidence are they going to provide to you? Now, most supporting evidence is not all in English. So you've got to have belief that the information that's being provided to you does actually support what it is that they are maintaining. So, for example, an agency has told us that you're absolute rubbish because you don't get tax registration in Germany for a self-employed person in a month. Well, the answer is, of course you don't, because no one does. But what they were being told and sold was the application, the Fragebögen, was submitted within a month. But that is not answering the question. There's nothing wrong with submitting a Fragebögen, but you've got to be realistic about the fact that you do not get registrations in 5 minutes and you are simply being sold a porky. That's what people are telling you. So do they know what they're talking about? What experience have they got? What qualifications do they have? Do they have specialist departments? Do they have an immigration department? We have an immigration department. Do they have R&D people? Who's in that R&D people? We've got members of the Chartered Institute of Taxation, we've got ACCAs, FCCAs. We have that knowledge in-house. So we're not just talking out of our hat. We don't know everything, but we're able to discern what we're being told by our advisors also makes sense. So my advice is go and check the professional and other credentials of the people who run the management company. Because if they don't have any background in this and they're just in it as a business, you're unlikely to be able to get all the aforementioned stuff. Who regulates them, if anyone? So I'll come to that in a second. And like you said, what's their experience in a given market? General experience doesn't suit you. There are a lot of umbrella companies in the UK over the years who said to us, we want to expand internationally, but most of them have given up. So it's the fact that you can do it in the UK and you can run PAYE on one solution does not necessarily qualify you for running 3 or 4 or 5 different solutions in n number of countries. You should take out references. If it's a UK company, you should go to Companies House, and in 2 minutes you will find out if they have a negative balance sheet. Why would you want to send your money to a company that is technically insolvent? And I see so many cases of this happening. So that's what I would say. Now, what is track record? Well, obviously there's no hard and fast rule, but I would say that if a claim is overblown, you should look at it very skeptically. Now, I remember one company that claimed to cover 124 countries 9 months after they'd started up in business. So, you've got to go and ask yourself some questions as to whether you're prepared to believe this. Now, what about regulation? What is regulation? Well, the obvious people who are in the regulation business, I suppose, are people like APSCO and FCSA, the Institute of Chartered Accountants in England and Wales. You've got NEN people in the Netherlands. You've got professional passport. Now, the main thing about these is they're predominantly UK-based. Now, we have approached some of these bodies and we've said, look, there's a gap to be filled here. On the international side, what assurance can we give to recruitment businesses and also, even not more importantly, to contractors? That what they're getting is a quality product. And the response has been that we have our hands full just doing one jurisdiction. We just don't have the resources to do it, probably. I'm not sure they don't see the market there, but it is a huge undertaking to do this. So if you're looking at someone like APSCO and FCSA or any other regulator, you've got to ask, well, what do they do when there's a miscreant in the camp? What are they actually doing when they find malpractice? How many people have they asked to leave their organizations in recent years? And, well, I'm not going to go into too much detail. It's all over the press, but not much assurance to the general public, I would say. I mean, I'm not saying that they're not doing a bad job and it's not in good faith, but does it provide real assurance, particularly to a contractor? And I would say it probably doesn't. Now, the best example, I think, of where regulation does work is in the Netherlands, where you have NEN 4400. And they have two flavors, one for resident companies and one for foreign employers. They do set out their requirements rather like FCSA does. I think FCSA's program is extremely good, but they audit every 6 months. And this is the core thing. They audit, and if you're not paying the right tax and social security, you get warnings, and eventually they will eject you from NEN. And this is the right way to go. And frankly, if I was going to contract in the Netherlands, why would I go to anybody who doesn't have NEN 4400? So this is the only one that's effective in a great model.
Yeah, and I think, thank you, Kevin. And I think we all agree that, that regulation really is key. Well, we've reached the end of the session. I'm really sorry, we've just run out of time. We really hope that we've given you some food for thought. Thank you so much to David and to Kevin for their
pleasure. It was very good to be here.
And obviously to you all for watching. So if anyone does have any follow-up questions, you can find all our contact details in the speakers tab of the conference portal. There is now a 30-minute break in the conference, so do feel free to check out the exhibitor booths, visit event chat, or look at the on-demand videos. And then the next event is on the live stage at 1:10 second panel discussion. So thank you again, everyone.
Thank you, Bernie.
Thank you very much.
Thank you.